Oklahoma is a state that many landlords consider business-friendly, and the habitability framework here reflects that. But even in a landlord-favorable state, there are clear obligations you need to meet. Let's break them down. Oklahoma's landlord-tenant law is found in the Oklahoma Residential Landlord and Tenant Act, Title 41 of the Oklahoma Statutes. This act was modeled in part on the Uniform Residential Landlord and Tenant Act, but Oklahoma made several modifications that tip the balance toward landlords compared to more tenant-protective states. Under Oklahoma law, landlords must comply with building and housing codes that materially affect health and safety. You're required to make all repairs necessary to keep the property in a habitable condition, maintain electrical, plumbing, sanitary, heating, ventilation, and air conditioning systems, provide running water and reasonable amounts of hot water, provide trash receptacles, and arrange for removal where applicable, and keep common areas clean and safe. Now here's one thing that makes Oklahoma interesting. The state explicitly allows landlords and tenants to agree in writing that the tenant will handle certain repairs and maintenance tasks. This can include things like minor repairs, lawn care, and even some maintenance of systems and appliances, as long as the agreement is entered into in good faith, is supported by adequate consideration, and doesn't waive the landlord's obligation to maintain essential services like plumbing, heating, and structural safety. When a habitability issue comes up, Oklahoma follows a notice and cure process. The tenant must give the landlord written notice identifying the problem. The landlord then has 14 days to make the repair. If the issue involves a condition that poses an imminent threat to health or safety, the timeline can be shorter. If the landlord fails to make the repair within the required window, Oklahoma tenants can pursue several remedies. They can seek damages equal to the rent reduction reflecting the diminished value of the unit. They can obtain a court order requiring the landlord to make the repair. Or, if the failure involves an essential service and persists after proper notice, they can terminate the lease. One important distinction: Oklahoma does not have a statutory repair and deduct remedy. Tenants cannot make repairs themselves and deduct the cost from rent unless the lease specifically allows it. This is a significant difference from states like Oregon or Washington, where repair and deduct is written into the law. Oklahoma does offer retaliation protections, but they're more limited than in some other states. Landlords cannot retaliate against a tenant for making a good faith complaint to a government agency about code violations, but the scope of protected activities is narrower than what you'd see in states with broader anti-retaliation statutes. For the full guide to Oklahoma habitability laws, visit tenantscreeningbackgroundcheck.com and subscribe so you don't miss the rest of our state-by-state series.